establishment carrying on public utility service. Strikes Patterson has aptly remarked strike as a boil on the body and is indicator and symbol of industrial unrest. Following are the conditions which are required to be fulfilled before going on strike in breach of contract of service in public utility service. Number a person employed in a public utility service cannot go on strike without giving a notice of strike within 6 weeks before striking. Such a notice is not necessary where already a lockout is in existence. Notice may be given by union or representative of the workman elected to do so. A notice of strike will not be effective after 6 weeks from the date it is given. So the strike must be effected within that period. If strike is not made within the period of 6 weeks, then after expiry of this specified period, fresh notice has to be given. Number B, a person employed in public utility service shall not go on strike within 14 days of giving such notice. Thus, a strike can take place only within the last 4 weeks. Number C, no person as employed shall go on strike before the expiry of the date of strike specified in the notice. Number D, no person so employed shall go on strike during the pendency of any conciliation proceeding before a conciliation officer. It may commence only after 7 days of its conclusion. Strike, as defined in Clause 7 of the Section 2 of the Act, means a cessation of work by a body or person employed in any industry acting in combination, or a concerted refusal, or a refusal under common understanding of any number of persons who use or have been so employed to continue to work or to accept employment. At least there must be two persons for strike as per the definition. Concerted refusal can be between two persons only. The length or duration of the period of strike is not important. What is important is the refusal or cessation of work, that too without giving notice to the employer. This agreement is a must. Ram Swarup versus Rex AIR all 2004, explaining the essential elements of strike. The Supreme Court has held in Northbrook Jute Company versus its workmen AIR 1960 SC 879 that the refusal to do the work which employee is not bound to do is not strike. Joint action or refusal is necessary element. Causes of strike. Number A, demand for reconsidering the issue of retrenchment, expulsion, or suspension. Lockout. According to Section 22, Clause Subsection 2 of the Act, no employer carrying on any public utility service shall lock out any of his workmen. No workman doing public utility service person. No employer carrying on public utility service shall lock out any of its workmen without giving them notice of lockout within 6 weeks before locking, without 14 days of giving such notice, before the expiry of the date of lockout. Hi, welcome Priyansi. Within 14 days of giving such notice, before the expiry of the date of lockout specified in any such notice as aforesaid, during the pendency of any conciliation proceedings before the conciliation officer, and 7 days after the conclusion of such proceeding. That means there are some conditions which has to be fulfilled before a employer carrying on public utility service shall lock out any of his workmen. So what are those conditions? Without have to give 6 weeks lockout notice of lockout within 6 weeks before locking. Have to give as such notice 14 days within 14 days of giving such notice before the expiry of the date of lockout specified in any such notice as aforesaid. During the pendency of any cannot lock out during the pendency of any conciliation proceeding before a conciliation officer, and 7 days after the conclusion of such proceeding. Cannot lock out before the expiry of the date of lockout specified in any such notice as aforesaid. The term lockout has been defined in Section 2, subsection 1 to mean that the closing of the place of employment or the suspension of work or refusal by an employer to continue to employ any number of persons employed by him. No doubt the strike and lockouts are the two sides of the same coin. A judgment to this effect is given in Sri Ramchand Spinning Mills versus State of Madras AIR 1956 MLD 2241. It was held that in this case there are two weapons in the hands of the employees and the employers respectively. Its aim is to bring pressure on the other party to concede the demands. Lockout is counter of strike. See Kariveta State Kotagiri versus Rajmani. There are three essential requirements for a lockout. So, what are three essential requirements? Number one, there must be closure or suspension of work or a refusal to employ. Number two, it must be the consequence of an industrial dispute or in anticipation of an industrial dispute. And number three, it must be intended to compel the employee to accept certain terms or condition of employment. Notice from the above, it follows that in the case of a strike, the workman, and in case of a lockout, the employee must give a notice of the same before 14 days from the date of strike or lockout, as the case may be, and after 6 weeks and after 6 weeks before the date of strike or lockout. The notice of strike or lockout shall not be necessary when there is already in existence a strike or, as the case may be, lockout in public utility service. But the employer shall sends intimation of such lockout or strike on the day of which it is declared. To such authority, to such authority as may be specified by appropriate government, either generally or for a particular area or for a particular class of public utility service. Rule 71 of the Industrial Disputes Central Rule 1957 requires that the notice shall be in Form L. The notice of strike in the case of strike shall be given by such number of persons to such persons or persons and in such manner as may be prescribed, and the notice of lockout in the case of lockout shall be given in such manner as may be prescribed. In on any day an employer receive from any person employed by him any notice of strike or gives to any person employed by him any notice of lockout, he shall within 5 days thereof reports to the appropriate government or to authority as the government may prescribe the number of such notices. The leading case on the subject in Buckingham versus Carnatic Company Limited versus worker of Buckingham and Carnatic Company Limited year 1953 SC 47. The facts of the case were as follows. On 1st November 1948, the worker of Buckingham and Carnatic Company Limited demanded holiday in the afternoon due to a solar eclipse on that day. The management did not accede to the demand. This led to the stoppage of the work by a section of night shift workmen from 5 pm to 10 pm. The management treated it to be illegal strike. It took the form of an industrial dispute and was referred to the Industrial Tribunal, Madras, for adjudication. The tribunal held that the strike to be illegal as the textile industry was notified as public utility service and as the works was stopped without any notice required under section 22 of the act. Both the parties went in appeal against the judgment of the tribunal to the labor appellate tribunal, which upheld the contention of the management. The labor appellate tribunal also held that the stoppage of work was not a strike and thus did not constitute a break in service. The punishment was set aside. The management filed the appeal in Supreme Court. Time factor, that is duration of a strike, is not very important. Duration of strike is not very important. It may even for a few minutes or hours provided other ingredients are present. State strike is not proper. To be present at the place of work and still doing no work is treated as an offence of trespass and grave misconduct. This is ruled in Saramusa Sugar Works Private Limited versus Sobarati Khan AIR 1960 SC 160. Right of strike is not a fundamental right. The principle is held in Kameshwar Singh versus State of Bihar AIR 1962 Supreme Court 1166. 1166 strike and staging, dharna, or procession is no doubt a right but not fundamental right, as is ruled in B.R. Singh versus Union of India, 1989 to LLJ 591 SC 591. Strike versus lockout. Supreme Court held that it was clear from the fact on the record that the workers were acting in concert in suspending the work. All the necessary ingredients of the definition of strike under Section 2, subsection 9 were present to constitute the stoppage of work. A strike, though it was for a few hours only, it was not a case of an individual worker's failure to turn up for work. It was concerted action on the part of a large number of workers. It was illegal strike have been declared without prior notice required by Section 22 of the Act. In Compton Grips versus Workman AI 1978 SC 1489, it was held that a workman is entitled to wages for a period of strike only when the strike is legal and justified. Likewise, it has been laid down in Spencer and Company Limited versus Workman 1966 1 LLJ 714 LAT that if striking workmen are dismissed from service, it can claim reinstatement only if it was established that the strike was the result of unfair labor practice on the part of the employer. So that's all about strike and lock. But if you find it useful, like, subscribe.